Can the Commission on Elections be held liable for expanded withholding tax despite its tax exemption, if a government agency, exempt from direct taxes, fails to withhold taxes on supplier payments, should it still be held liable? This was the shocking issue the Supreme Court had to decide. This is the 82nd case out of the 160 cases decided by Associate Justice Mario Lopez, chairperson of the 2024 Philippine Bar Examinations. Don't miss out on important legal insights. Subscribe to our channel for content that could save your life someday. Case title: Commissioner of Internal Revenue vs. Commission on Elections, GR number 2441552475008, date of promulgation, May 11, 2021. In May 2008, the Commission on Elections, COMELEC, entered into contracts with Smartmatic Technology Incorporated and Avante International Technology Incorporated for the lease, with an option to purchase, of electronic voting machines for the Autonomous Region in Muslim Mindanao, ARM, regional election. Believing that the procurement of election materials and equipment were exempt from taxes and import duties under Section 12 of Republic Act, R.A. No. 8436, as amended by R.A. No. 9369, COMELEC did not impose or withhold expanded withholding tax, EWT, on the payments made to these suppliers. On April 23, 2010, the Bureau of Internal Revenue, BIR, issued a letter of authority to examine COMELEC's books of accounts and accounting records for all withholding taxes for the year 2008. The investigation led to a deficiency EWT assessment against COMELEC amounting to 30,645,542.62 pesos for failing to deduct, withhold, and remit the required tax on income payments made to Smartmatic and Avante.
After receiving various notices and attending an informal conference, COMELEC received a preliminary assessment notice on June 13, 2011, assessing it for a deficiency EWT of 45,592,340.89 pesos. This was followed by the final assessment notice and formal letter of demand on January 13, 2012. COMELEC's protest was denied by the regional director on October 30, 2012, prompting COMELEC to interpose an administrative appeal to the Commissioner of Internal Revenue, CIR, which was also denied on October 16, 2014. Subsequently, COMELEC filed a petition for review with the Court of Tax Appeals, CTA, on November 18, 2014, ruling of the CTA Division. On August 2, 2016, the CTA Second Division rendered its decision, partly granting COMELEC's petition. The CTA Division agreed with the CIR's position that COMELEC's duty as a withholding agent on income payments to its suppliers is distinct from its exemption from the payment of duties and taxes on the purchase, lease, rent, or acquisition of election materials and equipment from local or foreign sources under Section 12 of R.A. No. 8436, as amended. The CTA Division emphasized that COMELEC's exemption refers only to direct taxes. Here, the deficiency assessment arose from COMELEC's failure to withhold EWT on the lease contract payments to its suppliers. However, the CTA Division ruled that COMELEC is not liable for deficiency interest under Section 247(b) of the 1997 National Internal Revenue Code. As amended, Tax Code, which imposes the liability for accrued interest on deficiency tax on the employee responsible for withholding and remittance of tax, COMELEC sought a reconsideration. On January 3, 2017, the CTA Division issued an amended decision, reiterating that COMELEC is not liable for deficiency interest, thereby ordering COMELEC to pay only the deficiency basic EWT of 30,645,542.62 pesos.
Only the CIR filed a motion for reconsideration of the amended decision, asserting that COMELEC should be liable for the entire amount, including deficiency interest, arguing that it is a constitutional commission not covered by the enumeration in Section 247(b) of the Tax Code. The CTA division denied the CIR's motion on May 9, 2017. Both parties then elevated the matter to the CTA and Bank, ruling of the CTA and Bank. The CTA and Bank, in CTA EB number 1581, dismissed COMELEC's petition for failure to obtain the required affirmative votes to reverse the CTA division's amended decision. It also denied the CIR's petition in CTA EB number 1660, affirming that the COMELEC is liable only for the deficiency basic EWT and not for deficiency interest issue in the Supreme Court. The primary issue before the Supreme Court was whether COMELEC, despite its tax exemption under RA number 8436, as amended, was liable for the deficiency EWT on payments made to its suppliers. Decision of the Supreme Court. The Supreme Court ruled that COMELEC is liable for the deficiency EWT but not for the deficiency interest. The court clarified that the exemption under Section 12 of RA number 8436 applies only to direct taxes and does not cover the obligation to withhold taxes on income payments to suppliers. The withholding tax is a method of collecting income tax in advance, and COMELEC's duty to withhold EWT is separate from its tax exemption status. The Supreme Court upheld the assessment for the deficiency basic EWT of P30 645 542.62 but confirmed that COMELEC is not liable for deficiency interest. The responsibility for the accrued interest on the deficiency tax lies with the responsible officer for withholding and remitting the tax, not with COMELEC itself. Important doctrines. Withholding tax obligation. Withholding tax is a method of collecting income tax in advance. Entities obligated to withhold tax must do so regardless of their tax exemption status. Exemption from direct taxes.